And you're still there?
I'm still here.
Perfect. Okay, so I around the time that you took the survey, there was four answers. So if it's all right with you, I might just get your birth year, and then I could find it pretty easily, and then we can match up the conversations.
Sure, 1963.
Thank you so much.
And that would be something that's private because people could use that for identity theft.
Definitely. And so I'll go over that with you on record now, just so you know we are recording and you're consenting to that.
Yes, very much so.
Yes, and we are still going to keep this anonymous. In no way are we going to link your contact information or your name in our results or in anything we publish. It's just me who's going to know that this survey was taken by you, and I won't even pass that on to my research team.
Okay.
Great. So I don't have any specific questions. I was just hoping that, yeah, I'd like to hear what else you didn't put in the survey that you'd like to tell us about the CRT experience.
Okay. Um, what what would be good though
Yep.
for me? Uh, um, I don't have a copy of the survey in front of me, and it had some things I tweaked. Oh, I wish I could talk about that.
Oh,
It just gave.
I can send that to you actually. I
Sure.
can email it right now. Just 2 seconds here to make sure I have the right one. One. Okay, it's coming to you right now.
Sounds good.
Let me know if there's any issues in a minute here.
Okay. Just looking to see if it's arrived yet.
Perfect.
Let's see. I think it's here.
Okay, great.
There we go. Okay. All right. Okay. Use the consent. Okay. So um, with the Solution Explorer, I used it twice. The first time, it actually resulted in a proceeding,
Okay.
and and um, what I found with the Solution Explorer is that it didn't really. It was very very simple, and it didn't really um, check to see like the questions in it didn't ask um, whether or not it would be something that would fall under the jurisdiction of the CRT. And one of the things that would help is if the Solution Explorer, when we get started, would ask for um, questions to find out whether it's in the jurisdiction of the CRT. So let's say, does it have to do, is it a problem with strata? And if you answer with the strata council, yes. Does it have to do with the conduct of the strata council? And if it's true, all of a sudden you've got an issue. Under Section 33 of the Strata Property Act, which is the consequences of Sections 31 and 32. So if there's any issues with the conduct of a council member, it's pretty much not going to be within the jurisdiction of the CRT because Section 33 is outside the jurisdiction of the CRT.
Okay.
And that's just an example. There's about a dozen sections under the Strata Property Act that are outside the jurisdiction of the CRT. If it has to do with the forced sale of the property, it's outside the jurisdiction of the CRT. And questions like that, if it's a strata issue, to determine whether or not it's within the jurisdiction of the CRT, should be part of that Solution Explorer, because it'll save people a lot of time, but also it probably won't save, using the CRT, it won't save the CRT any time until it comes to an application. If the person makes an application, it goes through to a facilitator, then the facilitator goes, oh, wait, this is outside the jurisdiction. Well, that could be several months down the road.
Right.
And it's going to then trigger a file. It's going to trigger the facilitator having to use this. And so the Solution Explorer should be asking very specific questions to determine whether it's within the jurisdiction of the CRT. Another series of questions should be, is it within the jurisdiction of the $5,000 limit of small claims? Or if it's a motor vehicle accident, how does the person determine whether it's going to be within the $50,000 jurisdictional limit? And so it should ask questions, if this is a motor vehicle accident, will it include wage loss? How long have you been injured? And questions such as that, so that it can determine, hey, you need to go see a lawyer. Your doctor says you're going to be out of work for 2 years. They're going to try and get you up and running within a year, but you've had serious injury. It's not just soft tissue damage. So these kinds of questions should be asked in the Solution Explorer right away to determine jurisdiction, because that would facilitate a whole bunch of things. If it is a small claims procedure, that's the only one where you may want the Solution Explorer to help resolve the issue or determine whether there's a prima facie case, either for defense or for filing a complaint, to reduce the number of files that are started in the CRT. Because one of my observations is that the CRT is already backlogged. People are waiting years for some of the more complex files to go through, and by the time they go through, oops, sorry, it's outside. We just realized it's outside CRT's jurisdictional limit, and now you've got an issue with the Limitation Act. Can you now move it on into the Supreme Court? And that's my next thing is that in small claims, if you go through small claims, inside the Act, there is a provision to have the small claim proceeding move seamlessly into the Supreme Court, and the file date remains the original file date of the small claims action.
Okay.
Whereas with the DCCRT, I don't think there is that. I'm not a lawyer and I don't remember for sure. But I don't think if they get to 6 months down the road, there's a way to go, oh, wait, this was outside the jurisdiction of the DCCRT. You have to now go start a whole new claim with the Supreme Court. And did the filing of the CRT claim stop the clock on the Limitation Act? That they've wasted 2 years at CRT.
Right.
So that was my first one about the Solution Explorer.
All right.
Was testing jurisdiction.
All right. That's great. Thank you.
How effective was the Solution Explorer for me? It wasn't at all. Well, it wasn't. It was very, very. The effectiveness was very little because the Solution Explorer didn't actually provide a solution.
Right.
What it provided was just a hindrance to get to the application. But if it did something effective like test for jurisdiction, that would be helpful. If it did something like, okay, ask me what evidence do you have for your claim, that would be helpful. And gear it more towards first of all, creating the files that will be necessary to move forward in a case so that, if you do not have these things available, don't bother. Stop right now. If there's no way you can get this information, you're not going to have a case. You won't be able to prove it.
Right.
So those are my comments about the Solution Explorer. I think it is an idea. It is something that is necessary so that people can come to a solution without actually filing. But it's just when it, like here in question 17, like in the strata law, is it a fairness or a nuisance case?
Right.
Start asking questions to categorize the type of file it is. If it's a motor vehicle accident, okay, so I didn't go into it in depth on the motor vehicle side because for me it was all about the strata. And even in the strata, it should become more granular and get down to sections of the act that may be covered. And the way that should be is that the using AI, having the act available, and finding keywords inside the act. Oh, is this where your problem is? And ask point blank. Put up the section of the act that might apply to their situation. Okay, and start building the case for them. And once it comes to the end, test to see whether it's something that CRT can handle, not just from a jurisdictional point of view now, but does this person really have a case, a prima facie case? And it is something that can very easily be done. And at this point, the Solution Explorer should start to make suggestions. Okay, have you asked the Strata Council for the document? Have you, if it's a motor vehicle accident, were there witnesses to the accident? Were the police called? Was an ambulance called? And in the strata, well, in small claims, it would be, have you sent a letter demanding the money that you say was taken from you, explaining your position? No, okay, well, here's a format that you can use to ask for payment. This is the form that you can use to ask ICBCs for witness statements. so that people can start to put together organize their evidence so that there's no big hurdle 6 months or a year down the road, and then finding out that, oh wait, there's absolutely no evidence, or people go out and they, oh, you know what, I'm going to lose this case, so I'm going to go create the evidence now. In one sense, it's a good thing, because if people do that, they'll see, oh, well, was made 6 months after the fact or a year after the fact. How much weight should the adjudicator give to it? So actually get the Solution Explorer getting to the point where it should say, okay, you need a lawyer, you don't need a lawyer, this is outside your jurisdiction. These questions to reduce the number of files that show up on the case.
Right.
Okay.
Well, that's
so. Yeah. Go ahead.
Oh, I was just going to say this is all very helpful, and I apologize I'm not saying much. I'm just trying to not make this so much of an interview as adding to the survey, if that makes sense. I am listening.
It does, and no, I thought you were.
Perfect.
Now, do you have questions for me? Because that was the big chunk that I had for the Solution Explorer part.
Right. I don't think so. I think that's all been great and very, very helpful. So I really appreciate it. Yeah.
Okay. So, like I said, part of the issue, though, is in the Act, and that ability to seamlessly transition from the CRT to either small claims or to the Supreme Court should be in the Act, and it should be flagged in the Solution Explorer. Okay, next.
All right.
When you pursue a claim with the CRT, now here is where things where I thought things were really a challenge. The first step was contacting a facilitator. Well, you made your application, and somebody reviewed the application to see if it's something that the CRT could help with. And at this point, going through the Solution Explorer, it should give whoever is vetting the application to make sure that there is a valid, at least a prima facie case that can be handled by CRT. If the Solution Explorer already did that and started organizing the files and sections of whatever laws would be available to the CRT, if that was already done, when it comes time for a human to be involved, you've already hopefully vetted 10 to 20% of the people who are coming into the CRT. And I don't know what percentage of cases that show up at the CRT that you actually say, hey, look, you really don't have a case based on what you told us. I don't know what percentage that is.
Right.
But when the application comes in, the Solution Explorer should have helped to build that application so that it makes sure that the case is within jurisdiction, but also that there is a case, at least the bare bones of a claim. Because some claims, some parties don't have a claim, and some parties don't have a defense.
Right.
So, when the claim is pursued, one of the things that happened was facilitating the facilitator was great, but she didn't have the authority to say, hey, you know what? She even told one of the parties that, hey, look, you don't have a case here. You don't have enough. And the party went out and created a report that really had no basis, and it really was questionable as to its authenticity. It should have carried no weight, and that was an issue. And they still pushed forward. They wouldn't settle because there was no incentive to settle. And there should be an incentive. In small claims, Section 20.5 of the Small Claims Act, if during settlement conference or the trial conference, the judge says, hey, look, you don't really have a case. If you proceed forward, there will be a penalty if you lose, because we don't really see a case here. You may have one, but we don't really see it. And, at the trial conference, they're looking at all of the evidence to make sure that everything is there. Now, they don't have witness statements. They just have a description of what the witness is going to say in the witness list. Unfortunately, I had to go to small claims as well. So I went through that process. And the Section 20.5 helped me. I actually won in that case as well. They decided to go forward. But because there was a Section 20.5, they were punished for it. And the same thing should be done in the CRT. You don't want frivolous cases to move forward because the CRT is already getting a lot of cases where there really wasn't a case to begin with. And my case in the CRT was another one of those cases. The other side did not have a case, really. And I won, of course. But because of the false evidence that they presented, I had to go out and get a bunch of reports and build a much stronger case for myself to deal with essentially a report that how to put it, it really didn't make sense and didn't create a prima facie case defense for the other side. But I didn't get compensation for my expenses. And the CRT needs to be a lot more generous. If somebody has to generate a report, in the Supreme Court, it's up to the person to determine whether or not it's frivolous or if it's something that's necessary to defend their position or to move a case forward. And that is the other thing, is there should be more teeth to the CRT in order to keep the number of cases down. Because what I see happening is similar to what's happening in the Supreme Court as well as in provincial court, is these great ideas start and then they're inundated by cases to the point where nobody can get anything done because all the judges or adjudicators or facilitators are busy. They just, their caseloads are too full. And justice delayed is justice denied, really.
Mm-hmm.
the CRT is supposed to be faster. I mean, the CRT should have, any CRT case should be simple enough that it can be heard within a year. And the Solution Explorer should have determined that. This is something simple enough for the CRT. But if it's something that, involves a strata that has breached a whole bunch of different sections of the Strata Property Act, or even that nobody knows who is the Strata Council representing the Strata Corporation. One group says they do, another group says they don't, another group says they are the ones, then, these issues become too complex. And the CRT has in its basis that if it's too complex, it has to go to the Supreme Court. The Solution Explorer should determine that. Next, when you are with the facilitator, if they determine, they spend a number of sessions with the parties on their own and then together in settlement conferences. If there's a settlement offer that is reasonable, or if the case really does not have, or one of the parties does not have a case at all, this warning should be good. In provincial court, it's 20% of the value of the amount of what's claimed. I think it should be a flat fee of anywhere from $500 to $5,000, and that should be determined by the facilitator. You know what? You really don't have a case. I'm going to give you a very strong warning that it's going to be $5,000. And even the Solution Explorer should be able to evaluate that. And the reason I'm going back to the Solution Explorer to evaluate these things is that you want consistency. And every time where you put it into the discretion of a facilitator or even at the discretion of an adjudicator, such as for expenses, you'll have one adjudicator who will give expenses and another one who won't. And so you start getting inconsistencies in your ruling. And the CRT really needs to be careful of the consistency of the rulings because it undermines the faith that people can have in the system. Already a lot of lawyers are very cynical and they say, oh, well, if you get this judge, you get these kinds of rulings. If you get that judge, you get these kinds of rulings. So I overheard a conversation between two lawyers and they were saying, oh, well, so-and-so has that judge. Yeah, I'm going to be before such and such judge. I'm going to adjourn it so I can get a different judge because the judge that I'm going to get it will not rule in my favor, but if I get a different judge, he'll rule in my favor. And at least the different judges are ruling consistently. But we want the judges to have some discretion, but it should still be limited by the law. If that makes sense.
Yes.
Okay. And so it's really, really important that the penalty for failing to have a case, for proceeding on a frivolous case, should be there. Like I said, it should be based on how weak the case is. If there's absolutely no case, it should be $5,000. If it's an extremely weak case, but there might be a small window that they could win, should be $2,500. And if it's the evidence is really confusing, but it looks like they've got a case, then it could be $500 if they lose. Those are the things that should be determined. And it wouldn't be the adjudicator who determines the fine. It would be the system that says, okay, you've lost, so you're going to have, at the end of once the adjudicator is done adjudicating, that's when the penalty shows up. So the adjudicator should not be aware that there was a warning. The same thing happens in small claims, by the way.
Okay. Well, that's all very, very helpful. Thank you so much.
Okay. And when somebody responds to a claim, they should have to go through, I don't know if they do, but they should have to go through the Solution Explorer, and it should right away tell them, hey, look, you really don't have a case here. And that should be, if the Solution Explorer can do a weighted, there's 90% of cases such as yours, the other side is going to win. How do you would you like to have the opportunity to make a settlement offer now before people are involved at all? The other party has asked for documents under Rule 35.6, and the documents that they've requested fall under that. But under this, we found that 96% of persons who apply for a ruling in these cases win. Would you just supply the documents? And that is an example of when responding to a claim filed by somebody else, is that they have to go through the CRT, through the Solution Explorer, and before they can file a response.
Right.
And I skipped most of the responses because I didn't do that.
Right. That makes sense. And is there anything else you wanted to add, or?
I'm just trying to think if there is anything more that I wanted to add. The Solution Explorer at some point should be expanded to help people when it finds that you're not suited for the CRT. If it finds it's outside the jurisdiction of the CRT, it should actually come up with this, should actually test to see if it's within the jurisdiction of small claims. And if it's not within the jurisdiction of small claims, say you need a lawyer, you may proceed with a claim, but at this point, the Solution Explorer has found these items that would put the claim outside the jurisdiction of the CRT.
Right.
And that would help, again, to reduce the number of claims inside the CRT. And odds are, some claims are going to be missed that would have fallen within the CRT. But I think that if the Solution Explorer is tuned properly, they will be very few and far between. And at this point, the Solution Explorer is actually a big sieve. And you wanted to properly filter out those frivolous cases. And that's the most important thing, is if somebody doesn't have a case, or if somebody has an overwhelmingly strong case, it should be able to point that out to the other party so that a solution can come forward. And if the solution comes to it that it looks like it's going to be default judgment, then that's the other thing. If somebody doesn't file a response, you've got the default judgment, great. But there should always be, when somebody does not file a response, there should always be a penalty in every single case, because whoever it was probably realized that they didn't have a case, and if they would have filed a response, and in the response it should say, I agree, we're going to lose. And that's the thing, is to streamline it is, I agree with the claim this other party is advancing. I will comply. I'll provide the documents that the other party is asking for. And that, I see in the CRT, like I've done it before I started my case, I went through pretty much all the decisions that were done to date. And I saw a lot of them whereby parties were asking for documents. And quite often there were documents that the strata was supposed to provide, and they just refused to provide them just to be a nuisance. They didn't have any legal basis for not providing them. They just wanted to be a nuisance. And that's the thing, is that it would really solve a bunch of issues and reduce the number of cases going forward to the CRT, is if, especially for documents, that should be solved at the Solution Explorer stage, and if it's not, somebody should be paying a penalty.
Right.
Okay?
No, that's really, really helpful. I really appreciate it.
Okay.
Yeah, thank you so much. And if you do think of anything else that you'd like to say, you can always email it to us, or we could talk again, whatever works for you.
Okay.
Yeah.
I hope it really was useful, and it's not, you're not just saying that.
No, definitely it was. Yeah, you gave us a lot of useful information. If we did, I don't know if I included this, it's in the survey consent, but if we did want to quote any of your answers, we wouldn't attribute it to you or again, say who you were in any way. Would that be okay? Just use a quote?
Yes.
Yeah? Okay, great. That's one nice thing about the phone calls, is that you can get some really quotable information out of that. So.
Okay. Did you have any clarification questions or anything else for me?
I don't think so. That was all really, really well put. So thank you so much.
Okay. Thank you.
All right. We'll talk to you later.
Okay. Bye.
Bye.